Hey folks, James Abrinio. Let's talk about negotiation tactics with prosecutors, insurance adjusters, and defense attorneys. I actually, when starting to think about shooting this video, was considering doing separate videos, one for insurance adjusters and insurance defense attorneys, and one for prosecutors, or in Virginia, we call them Commonwealth attorneys. But as I started thinking it through, I realized that the process is pretty much the same, while obviously dealing with very different factual scenarios as well as law. The process to me, and in many ways, it overlaps. So I have a few rules when I'm negotiating with prosecutors. And so I'm going to start with the first one, and it's the golden rule. Treat others how you would want to be treated. Be kind. I know this is a bit generic and it seems assumed, but unfortunately, I've witnessed far too many folks negotiating, whether it's outside the hallways, in criminal cases, hearing other attorneys negotiating with prosecutors, or at least in my interactions with adjusters, insurance defense attorneys, where I see or hear about interactions with other attorneys. I feel like that rule gets lost. And oftentimes I can see attorneys representing individual clients, either against the government or insurance companies, going up to the representatives of the other party, being very aggressive, being rude, not allowing the other party, the other attorney or adjuster or prosecutor to finish their thoughts. And frankly, I just think that's a huge error. I think there is some belief that if you are negotiating on your client, that you need to be aggressive, that you need to be bold, that you need to use loud and strong language, be hyperbolic. But frankly, I just don't think that is in great service to your client. I think if you go in with respect, just like any other type of discussion, if you show respect to the other party, they should show you respect in kind. Now, to be clear, that doesn't mean that you will get the respect in kind. Sometimes there are jerks on the other side of the aisle, whether it's prosecutors, whether it's insurance adjusters, whether it's insurance defense attorneys. You can't control that. And occasionally there will be jerks on the other side. But in my view, and at least in my own life, I found that when I'm able to conduct myself with kindness and calmness, I end up being a better advocate for my client. And inevitably, it ends up with a better result. Because even if somebody's being aggressive to you and you can lower the temperature, as far as from a negotiation standpoint, that's usually better off for your client. Second rule, know your audience. And what do I mean by that? Whether it is an adjuster, a prosecutor, an insurance defense attorney, you got to remember that at the end of the day, they have a job to do. Usually, again, not always, but usually they try to not take things personally. And all they're trying to do in a lot of times is trying to move the file, their case, from one side of the table to the other so they can move on. A lot of times prosecutors and insurance adjusters work in high volumes, whereas you and your attorney, if we're working with you, we work relatively low volume, high complexity cases. Usually the individual representative for the plaintiff or the accused criminal will have less volume than a prosecutor or an insurance adjuster. So you just got to remember that while obviously you want to make sure that you're setting your client apart, they're just trying to do their jobs. And if you don't respect that, I don't think, again, respect won't be shown on the other side. Appreciate what their priorities are and must be. Let's say you're representing on a criminal case, you're representing your client who is charged with a violent offense, and there is a victim involved. If you don't appreciate that the victim is going to be speaking to a prosecutor and expecting a certain outcome, or at least a certain response from your client, if you don't appreciate why the prosecutor wants that, and if you can't understand that they're going to, in certain circumstances, have their hands tied about things that they can do, then you're not going to be able to negotiate. Because if you're going to be coming from a position that in no way possible, shape, or form they will ever be able to agree to, well, then you're not doing your client a service by saying or representing to that person that you're going to be able to get that position, or pushing for that position that is just never going to happen. And we'll talk about it later, but sometimes cases just have to be tried. And again, going back to the first rule, being kind, if you're asking a party on the other side to not to do something that doesn't appreciate the position they hold, I think it ends up just resulting in aggression from them and bad expectations and bad outcomes. Another thing to be aware of is knowing in knowing your audience is obviously if you've worked with them before, personalities are very different from person to person. Prosecutors, insurance adjusters, they are human beings as well. They have different personalities. And so if you know them and you've worked with them before, that's useful because you hopefully have learned a little bit about them, learned about how they negotiate, learned about whether or not they're aggressive or not, learn about how they respond to aggressive behavior or respond to certain efforts, learning about their lives. Do they have family? Do they have friends? If they've been in a situation where maybe they can appreciate what's happening, knowing your audience, especially knowing that particular audience, can really be helpful. But even if you haven't worked with them before, at least making the effort to try to learn, whether it's asking about certain priorities they may have, or asking about what their position is, or asking if they can't make a move, why is it? Asking about their friends and family. That can be super useful because oftentimes if you can take the heat down, you can come up with creative solutions. The other thing is, another rule I tell people is know yourself. Some folks are going to be very persuasive being funny. Some are going to be more persuasive being more bookish and analytical. Some maybe, again, always being kind, but some are more blunt and some aren't. So I think that you need to understand who you are. If you are a lawyer watching this video, let's say you're a young attorney, maybe either you're in law school looking to be a litigator or you're just coming out, learning about who your authentic self is, I found is very useful in not only trying cases, but negotiating with other parties. Because at the end of the day, whether or not you're selling your case or your client to a jury, or you're selling your case or client to an adjuster or a prosecutor, it's all the same. While obviously there's going to be different arguments being made, the rules of the game are still the same. Understanding where the arguments are to be made, pressure points are to be pushed. Again, appreciating what the audience is willing to give and not give, and understanding their priorities is absolutely important, but also knowing how you yourself can get there and understanding the best methods for your negotiation approach is super important. Next thing is know the facts of your case. Know the law of your case. If you have strong facts and strong law, then you're going to obviously have more leverage either to push for a better result in the criminal case or more money on the civil case. And so if you're confident with your facts and the law, you're going to be able to persuade the other party, whether it's the prosecutor or the adjuster, in better ways about why your position is more reasonable. And if they start countering with certain things, if it's on the factual side or the law side, you're able to respond to that. But I also do want to be clear, by knowing your law doesn't mean you have to litigate your case right then and there, because a lot of times, again, you're going to reach an impasse where it may be better to save that for trial or for deeper in litigation, or if you're in a civil case, you haven't filed suit, but now you're going to file suit and get into discussions with the insurance defense attorney, where maybe the legal arguments are going to be better received, that kind of thing. But you need to know your case. And also, what is the value of your case? If we're talking about a personal injury case, what do you think the actual value of it is? Like, what is the dollar value? If we're talking about a criminal case, is it something do you think you're going to win at trial? Or if you're not going to win, know how much time do you think the judge or jury would give your client if convicted? So you can then, when you're negotiating, when you're talking with your client, you can properly advise them. But also in your negotiations, you know what your leverage is. And if it needs to go beyond that, if you need to show force by filing suit or going to trial, then that is fine too. Help them see your client as a person. Give them backgrounds about your client. If it's a criminal case, the lack of criminal history, or if they have a criminal history, the context of it. If there's a mental health issue, if there's a drug addiction issue, if there's context of relationship. On the personal injury side, letting them know about who your person was before the injury, how the injury and crash or incident has affected their lives, why this is different than just some standard file that they should be looking at and saying, what are the medical bills? I'll give you $500 more. Treat Making the adjuster and the prosecutor realize that you know your client as a person, and you know that because you're educating them. And I think this skill and this effort is not as often supported by a lot of attorneys. A lot of attorneys don't do this, so you're going to be setting yourself apart if you know those details. Help the adjuster or the prosecutor do their job by giving information that allows them to come towards your side of things, by giving them tools. They can then use those tools, that information, to then convince their side. So if they're talking to an alleged victim, if they're talking to an insurance manager, so they're trying to get additional authority, if you give them tools, whether it's the medical records and bills, but also the intricacies of what the injury recovery is, or again, on the criminal side, the context of what's happening. If you give them the tools, but again, not going too far, then you're going to make their job easier. And if you make their job easier, that means that they're going to be able to come to your side more. Now, again, no guarantees, but just something to think about. Now, when we're talking about the actual negotiation process, start high, they'll go low, and all the in between. So, of course, inherently, whether you're not trying to negotiate an outcome on a criminal case or trying to get a settlement, you're going to, whatever your position is going to be, you're going to go higher or lower depending on which side of the aisle you're at. And so you're not going to want to give away the store. You're going to want to leave room to negotiate. But that's the starting off point. As you get closer, there's going to be questions about, should you just cut to the chase and say, hey, let's split the baby? Sometimes that's appropriate. A lot of times it's not. And actually, there's been whole books written on this subject. I think there's a book recently, Never Split the Middle. I forgot exactly the title of the book that's been highly recommended. But by that, I mean not getting into, especially on the civil side, we're going to come down 500, they'll come up 500 and all that kind of thing. This goes back to knowing your audience, but as you learn your style and you learn who you're working with on the other side a little bit better, it may be that you show confidence by cutting to the chase. But again, every case is going to be a little bit different. Some cases you want to be more aggressive on. And again, it depends on the parties involved, the facts involved. But for instance, I recently had a case where I knew that the case was worth a lot. Now, there was a lot of insurance limits, so injuries were very, very significant. Insurance was very, very significant, but I was confident that if we went to trial, the jury would give even more money. And so what I said to them is, we want the insurance limits or we're going to go to trial and we're just going to withdraw our demand. That's a very aggressive approach. Sometimes it doesn't work, but if you make that approach, you better be willing to walk the walk. If you say, I'm going to withdraw this demand, if you don't make an offer, we're going to go to trial, you don't need to say it aggressively. But if you say it, then make sure to follow through with it, because especially if you're an attorney, reputation matters. And so if you're not willing to go to trial, that's going to get out at some point. If you're not willing to put your case up, that's going to get out at some point. So make sure that if you're being aggressive, that you can back it up. And just because negotiations fail and you're not able to come to an agreement, that does not mean that you failed as a negotiator. The reality is some cases just need to be tried. Sometimes your position is going to be so far from a prosecutor or an insurance adjuster or an insurance defense attorney that it just has to go in front of a jury. So I find this a lot, for instance, on my personal injury side, brain injury cases where somebody has suffered a concussion and post-concussive syndrome. I've got a neurologist saying that they've suffered permanent brain injury and they're not going to get better. But there's no findings on MRIs. And the insurance company is going to find a neurologist or a neurosurgeon to say that, or some other expert to say that your client's not really injured. They don't look injured. They're able to still work. And at the end of the day, a lot of times you can't meet those in the middle and you just have to try the case. And so sometimes you want to be in that position to where you just put it up. So just be aware of that. It's not a failure. And on the criminal side, I see this a lot in DUI cases where, there's a certain amount of time given the blood alcohol level. I don't think a judge is going to give any more time that they're offering. Sometimes you just got to try the case. That is not a failure. In my view, trying a case is just an extension of negotiation. So I hope this has been useful. Feel free to reach out if you have any more questions. But don't be afraid. Be confident. But at the end of the day, be kind. At the end of the day, the cool thing about trying cases, the cool thing about doing what we do, as opposed to like selling a house, we just walk away. In the civil world, in the criminal world, you can just go to the jury. If you disagree, you can always put it in front of a jury. So I wish you guys the best. Make sure to like and subscribe if you found this useful.